With that, I'd like to go ahead and introduce our speakers for today's presentation. We are joined by MarkMonitor domain management experts Kiran, Malancharuvil, and Janelle, McAlister. Kiran is the policy counselor for MarkMonitor, responsible for monitoring the legal, legislative, political, and regulatory environment around brand ownership. She represents the interests of MarkMonitor clients at ICANN through the intellectual property constituency, at INTA as a member of the Internet Committee, and at IACC as a member of the Internet Task Force. Kiran has taken a leading role defending brand and consumer interests on policy and advocacy issues related to the new gTLD program, Registrar Accountability, accessibility of website ownership data, and consumer fraud. She's a trademark attorney with experience in international and domestic trademark prosecution, litigation, anti-counterfeiting efforts, and brand protection counseling. Janelle is Manager Global Relationships for MarkMonitor Domain Operations. With 10 years of experience in the domain industry, Janelle has worked with a large number of registries on behalf of MarkMonitor to become an accredited registrar. Janelle manages the Domain Global Relationship team that is responsible for MarkMonitor's gTLD and ccTLD registrar accreditation. Janelle has worked with multiple ccTLD registries to implement account and domain security features, including registry lock. Janelle is a voting member of the Registrar Stakeholder Group at ICANN. With that, I'll turn things over to Kiran to get us started.
So last month, Janelle and I were in Helsinki, Finland to attend ICANN 56, the very first ICANN policy forum, and wanted to run through the highlights of that meeting, including some of the updates of the groups that are most interesting to us and to our clients, hopefully. Here's the agenda for today's call, and I think we'll just jump right in. So the policy forum took place from June 27th to the 30th, a much shorter ICANN meeting than normal, and it was in Helsinki, Finland. It was hosted by the .fi registry, and I will turn it over to Janelle to talk about them.
Thanks, Kiran. As she mentioned, this meeting was hosted by the .fi registry, which gave them an opportunity to discuss the upcoming changes to their policies and processes. So starting in September, the .fi registry will be moving to an industry standard registry-registrar model, which will make the management of .fi domain names more streamlined with industry standards. And they will also be removing the local presence requirement that they currently have, which will open up this TLD to domainers as well as the reselling of domain names in this TLD.
Who should be thanking you.
As Kiran mentioned, this was a smaller meeting with about 1,400 participants, which is roughly half the number that we see in the large policy meetings. The benefit of this meeting is it did allow some cross-constituency work, including a couple of meetings that Kiran and I participated in. One was a joint meeting between the IPC and the registrar constituency, which led to some, I think, meaningful discussions regarding as well as other topics. And with that, I'll pass it back up to Kiran to talk about some of the policy work highlights.
Thanks, Janelle. So the policy forum was a pretty interesting format from my perspective as the policy counselor here at MarkMonitor. The focus at ICANN meetings is often very high level, sort of aimed at getting community members interested and involved in the work that the policy groups are doing, but without any sort of in-depth meetings of the policy groups themselves, and without any sort of progress expected to be made at the meetings. This meeting was different. We had extensive face-to-face meetings of all of the PDPs that we're involved in, including the new gTLD subsequent rounds, the Consumer Choice Competition and Trust Review team, of which we're not representatives, but we do have colleagues representing our interests on CCT. We also attended face-to-face meetings of the Review of Rights Protection Mechanisms PDP Working Group and the Registration Directory Services, or Next Generation Whois Working Group. So we had multiple meetings of each. One was high level, sort of to make sure that the community members were up on the work that was being done. The second, more in-depth and more focused on actually moving the ball forward on the policy work. I thought it was interesting. It definitely takes some getting used to after years and years of attending ICANN meetings that have been very specific in the way that it's formatted. But I'm willing to give it another try next time to see whether or not this form can be sort of finessed and we can make good progress again and again. So the other focus of this meeting was cross-constituency dialogue. I'm the primary representative from MarkMonitor to the intellectual property constituency, and I'm the intellectual property constituency participation coordinator. So the IPC met with the registry stakeholder group, the registrar stakeholder group, as well as the ALAC, the At-Large Advisory Committee, and we found those meetings really fruitful. At a normal ICANN meeting, we don't have a lot of time because each stakeholder group is very entrenched in its own agenda to speak with each other. And so I thought that this meeting provided a really good opportunity for us to sit down and hash out some of our differences and explore ways in which we can continue to work together. And so we really had a good opportunity to sit down and talk across the table. And I'll pass it back to Janelle to talk about her cross-constituency dialogue experience as our primary representative to the registrar stakeholder group.
Thanks, Kiran. So as it was mentioned, so I'm our primary representative in the registrar stakeholder group. So I represent our interests when it comes to registrar operations, and with policy, procedures, and in this working group, we, as we mentioned, had a joint meeting with the intellectual property constituency group, as well as the business constituency group and the registry stakeholder group. So that would be the contracted parties had joint sessions. All of these were extremely valuable. I think we don't necessarily interact on a face-to-face basis and talk about cross-department policy on a regular basis, and I think this was, for me, one of the most valuable discussions that we had at these ICANN meetings. It led us, I think a lot of assumptions between the two groups were overcome, and I think we were able to actually have a dialogue that hasn't happened in quite some time. And with that, we'll move on to where we're at with new gTLDs. So we'll update the current program status, talk about next round, and RPMs. So to start with the current landscape, this graph shows steady increase in new gTLD domain registrations. We're coming up to 23 million new registrations, which number kind of blows my mind every time I see that continue to increase. But to look at what those actually are in a little bit more detail, we'll go on to the next chart. So we're seeing definitely a few of the new gTLDs are dominating the landscape. Specifically, examples like .xyz, .top, .wing, .win. And this isn't necessarily indicative of what brand holders are registering, but it is what is being registered more from a retail environment. One of the main drivers behind these numbers is we are seeing registries do what we call blitz pricing, or where they offer extremely low pricing on domain names in order to drastically increase the number of domains they have under management. XYZ was an example where they did a 3-day kind of discount blitz pricing where they were registering or allowing registrations for less than 10 cents a domain name, and they received over 800,000 in less than 24 hours. So as you can see, that is a significant jump with a very specific goal in mind, which is just to increase the actual domains under management. But it'll definitely be interesting to reevaluate these statistics in a year from now after domains are being renewed at a regular retail price. So next we'll talk about the new gTLD program. So there's currently over 1,000 new gTLD strings that have been delegated. with just over 1,200 registry agreements signed. So that is the initial numbers as of today, but there are kind of the next phase of this program is new gTLD registries changing hands. So we've already seen a few registries or a few TLDs change hands, and we're expecting to see more of that coming in the next few months, even within the next few years. We're also seeing registries are starting to get more creative with how they're launching and what their business model is. We've definitely, when gTLDs were originally launching, we saw premium name lists were generally about less than 1,000 domains, and now we're seeing premium lists at over 50,000 domains per TLD. So there is a drastic change in how registries are holding back premium domains and looking to make a significant profit from premium names versus general availability. And next, I'll pass it over to Kiran to talk more about universal acceptance and the Global Consumer Research Study.
Yeah, so on the universal acceptance front, there is a group within ICANN made up of a lot of really senior technical people in a lot of the registry and other affiliated groups and organizations at ICANN that is working on just exactly as it says, universal acceptance of the new gTLDs to make sure that email addresses that end in extensions other than the 22 legacy TLDs that have been, worked into the internet infrastructure are able to be accepted into forms and into other, search fields and et cetera. So the universal acceptance group is, as far as I understand, has actually finished their work and have sort of made their recommendations. And so I think we should see a drastic increase in universal acceptance across the ecosystem in the next coming years, which was a pretty big barrier and a really significant achievement of that group within ICANN. So we're happy to announce that that's sort of been moving forward. And then while I'm talking, I'll just skip to the final bullet point and say that ICANN's commissioned Global Consumer Research Study, Phase 2, was also published. We're going to talk a little bit about .brands, and then there'll be a slide specifically on that research study. It was designed to give a sort of very tight picture of what the new gTLD program really looks like, especially from a consumer standpoint, to inform the CCT team, the Consumer Competition, Choice, and Trust team. So we'll go through the findings of that study in a couple of slides, but we'll go back over to Janelle to talk about .brand development.
Thanks, Kiran. So .brand development, I think, is a hot topic. I think there's a lot of speculation, and I think people are anxious to see what the .brands are going to be doing with their TLDs. So currently, of the 1,236 TLDs that have a signed registry agreement, only 478 TLDs contain an executive, what's called Spec 13, which is the annex to the ICANN registry agreement that provides a TLD with .brand provisions. And we're closely monitoring to see who's using it, who's using a .brand, and what this means to other .brands. There's one .brand that appears in the Alexa 10,000 traffic ratings, which is an e-banking site for the French bank BNP, which ranks number 3,024 globally and number 80 within France, which actually is fairly significant that within a year .brand is getting up to 80 within a specific market. And then we also have .MMA, which is also owned by a French company and is a French insurance company. It has over 1,700 domain names registered and is using the strategy of redirecting 99% of the .MMA domains to existing subdomains of the primary website, MMA.fr. So the primarily they're doing this to customize insurance agency websites for French municipalities. And as we mentioned, this is definitely something that I think is another topic that will be changing drastically over the next year as the .brands start formulating and executing their business plans and what they plan to do with their .brands. So next, I will pass it over to Kiran to talk more about the ICANN Global Consumer Research phase.
Great, thanks, Janelle. Like I said, ICANN has commissioned several phases of a global consumer research study in order to inform the work of the Consumer Choice Competition and Trust, or CCT, review team. For those of you that are sort of new to the ICANN world, or maybe not as knee-deep as we are, which is understandable, the Consumer Choice Competition and Trust Review Team is a team that's essentially tasked with trying to figure out if the new gTLD program achieved the goals that it was meant to achieve when it was conceived in 2007. So it's a pretty big deal to try to figure out whether gTLDs have were actually worth it. So this phase showed an increased awareness of new gTLDs, but a decreased trust in new gTLDs. There appears to be a correlation between trust and registration restrictions, which we thought was really interesting. So if you've got a gTLD that is restricted to a specific kind of business or a specific geographic location or a specific community, for example, then apparently there is a correlation between trust and those types of restrictions. The consumer expectation is between purpose of the TLD and the content of the website, which I also think is really interesting, especially as we discuss in the subsequent rounds policy group whether or not we should be introducing or even restricting new gTLDs to sort of categorical representation, and then making sure that that the content of those websites are not. We wouldn't implement that policy at the ICANN level about content, but try to make sure that registrations are directed towards those people that we will be putting up content that is related to what the TLD points to. So, for example, .books will be websites that are related to .books, or .nyc will be websites that are related to businesses that have a presence in New York City. So I thought that was really interesting. And it is encouraging to see an increased awareness of the new gTLD program. I think a lot of folks, including ICANN, are working very, very hard on consumer education. It will be interesting to see. This was just published on June 23rd, just before Helsinki, and it will be interesting to see what the CCT review team thinks of this study, what the larger members of the community think, and how it is received in general. So on that, let's jump right into new gTLD subsequent rounds. The policy development process is underway. The group is meeting weekly. And very recently, they have finalized the 5 separate work tracks plus the overarching subjects group, which is a sort of fixed bucket of things that don't require its own work track but are sort of important issues that have been flagged by the community nonetheless. I will mention that the last time we mentioned that the leadership team was in place, Jeff Newman from RDS is a chair, along with Aubrey Doria from the non-commercial stakeholder group. Stephen Coates from Twitter was the 3rd co-chair. He has just announced that he will be stepping down due to a job change, which is taking him away from Twitter. And so we encourage folks who are involved in the new gTLD subsequent rounds PDP to consider a leadership role to replace Stephen. So we had some pretty good representation for brand interest through Steve, so if anybody else in the brand community wants to step up to that leadership role, I think that there should be some interesting discussions and calls for volunteers in that respect in the coming weeks. So what are the 5 work tracks that we're working on in this PDP? Process support and outreach is one. This is the one that is aimed towards addressing what some viewed as the failure of the new gTLD program to serve underserved and underrepresented geographic and community regions. So, for example, we fully expected IDNs to be a bigger deal in the new gTLD program. We wanted developing countries and developing continents to have better representation, and instead the applications were really heavily concentrated in the regions that we see are already dominating the Internet, including North America and Europe. So we want to, in this work track, we want to see what can be done, whether it's an application support issue, whether it's just an awareness issue, and we'll be working on that. The next is sort of a legal and regulatory bucket, which is about as interesting as you would expect, I guess. We're going to be talking about the contracts-based registry agreements, registrar non-discrimination clauses, public interest commitments, which is actually pretty cool, if you ask me, global public interest issues, reserved names, and those are all sort of issues that are near and dear to our clients' hearts, so we'll be participating really well in that. So the next is string contentions, objections, and dispute resolution. That will deal with string similarity issues, which was a big deal in the new gTLDs. There were a lot of strings that were called out for being too similar. Plurals and singulars was a huge issue that should have been addressed in the front end of the policy and instead was kind of a mess on the back end. We're going to be looking at objections, including legal rights objections and independent objections, community applications, accountability and challenge mechanisms, et cetera. So the next will be IDNs, technical and operational. That's going to deal with issues related to security and stability and resiliency, applicant reviews, name collision, which was obviously a huge issue for a lot of brands who saw their names end up on collision lists that were restricted from sunrise registration, which caused a whole lot of discussion at the time. And also, of course, IDN's non-ASCII script issues that were presented by the new gTLD program. And the final one is this bucket called operational implementation guidance. These subjects are to be determined. This is what I'm going to refer to as a sort of empty bucket that is going to sit on the side and wait for us to determine that an issue has more to do with changing implementation details than actually rewriting policy. And I guess I should have mentioned this on the top. And the goal of this group is to see what changes need to be made to the new gTLD policy recommendations from 2007. So if it's not a policy issue, if it's an implementation issue, then it can sort of get dumped into this operational implementation guidance, no policy bucket. And then, of course, the overarching subjects are things that will really come first in a lot of ways, whether or not we should continue the new gTLD program at all, whether or not .brands will go before regular or open TLDs, whether restrictions will be appropriate, the predictability of the program, those issues related to predictability of contracts and reserved names and objections from groups like the GAC, the Government Advisory Committee, application limits, et cetera. So a lot is about to start happening in the new gTLD subsequent rounds. There is currently a call out for volunteers for each of these work tracks. If any of them or all of them are interesting to you, I would encourage you to get involved. And for those of you that think this work is especially exciting, think about a leadership position because we've got one available. The last point I'll make about the new gTLD subsequent rounds is that there is a lot of coordination with other reviews. They will be coordinating with the CCT group. Obviously, the Competition, Choice, and Trust group, as I mentioned, that is going to be a big deal for the new gTLD program overall if it's found that it hasn't actually increased competition and increased choice and increased trust among consumers. And also, there will be a lot of coordination with the Use of Country and Territory Names Working Group, which obviously was a big issue for applicants such as Amazon and Patagonia, who had a sort of run-in, we'll call it, with the policies that were put in place about the use of country and territory names as top-level domains. Here's the timeline for the new gTLD subsequent rounds group. We've talked a lot about 2018 being the earliest that we would see any new gTLDs, which pretty much corresponds with this timeline. They're looking at initial report at the end of 2017, and final report would be in 2018. So I want to reiterate that 2018 is probably the soonest we'll see anything. Even if .brands are considered on a separate track, that would still have to be put out as an initial report for policy approval. and move forward to final report. So I still think 2018 is the most optimistic slide. So I wanted to address, we saw a question come through that asked if I meant 2017 instead of 2007. No, I did mean 2007. Those were the original new gTLD policy recommendations. Those were made in 2007 for the round that accepted applications through 2012. And are being implemented now. So we are updating the recommendations from 2007 with the hope to get new recommendations by 2018. So, oops, sorry, too fast. So the next group is the Rights Protection Mechanism Review. Significantly less complicated, I think, than the new gTLD subsequent rounds. It's been split into two phases. The first phase is going to concentrate on the trademark post-delegation dispute resolution procedure, or the TMPDDRP. These acronyms get more ridiculous every day. We've got the Trademark Clearinghouse, and then the Sunrise and Trademark Claim Service, and the URS, all in the bucket of phase one of the Rights Protection Mechanisms Review. After all of that is being reviewed, we will make those recommendations to the subsequent rounds group, likely, since they will be depending on the findings of this group in order to put the policies in place for the rights protection mechanisms moving forward, not just with new and subsequent rounds of new gTLDs, but actually existing all gTLDs, including legacy TLDs where that would apply. Some things obviously won't apply, like Sunrise. And so after all of that is done, we will enter into phase two, where we will concentrate on updating the policies of the Uniform Dispute Resolution Policy, or the UDRP, which is still vastly more popular than the URS for a lot of reasons, which this group will discuss, primarily remedy issues and burden of proof. So aside from just addressing the parameters of these specific RPMs, other issues that the working group is going to consider include overall functioning and effectiveness of RPMs, whether the RPM has the ability to fulfill its policy purpose, or whether certain registry practices are actually circumventing the original policy purpose of the RPMs, and whether or not we need to have additional RPMs or amendments to existing RPMs in order to sort of fill some of the holes that brand owners felt were present, allowing exploitation of brands, especially in relation to defensive registrations. So that's where we are with the Rights Protection Mechanism Review. I know that big issues for our clients include things that aren't listed here, including premium pricing and reserved names, and those issues that have been sort of brought up within the context of this group and just the entire time that the new gTLD program has been going on. We see a lot with exorbitant Sunrise pricing, really incredibly pricey premium names that relate to brands, and those issues will be addressed within the buckets of these main overarching issues. Most likely, I would imagine that they will be addressed during Sunrise discussion, but it's also sort of in the back of our mind in other issues for working group to consider. And it was, when ICANN staff solicited questions from the community about what issues the RPM review were going to focus on, they heard from us that we want the community to address these pricing issues. It might be a little bit more complicated than these sort of clearly defined issues are, especially because ICANN has some issues with understanding how their remit might allow policy recommendations to be made that affect market forces like pricing, but it's definitely something that's on the agenda to be discussed, and I would encourage any brand owners that consider that an issue for them to follow this group and to chime in where needed, because the worst thing that can happen is that we would expect our issue to be addressed and to have it be dismissed because there's not enough people saying that it needs to be addressed. So we're in the group, and we're pushing for those issues to be addressed, but we will need our colleagues and those people that ran up against those issues to be represented in this group. So this group has a timeline as well. You can see it, and we've got, we're currently in the phase, this is tiny type, so I'm sorry, but we're currently in the phase all the way to the left, which is the TMPDDRP. We're discussing that, and then you can see how it will go piece by piece. And they're looking at phase 2 starting in 2018. So now we're going to be talking about my favorite topic, Whois. So a couple of big things happened in Helsinki, or were discussed in Helsinki. Nothing is coming to a close or reaching any sort of milestone on any of these issues at this point. But two sort of big deals. The first is the Privacy Proxy Services Accreditation Final Report is still out for approval by the ICANN board. It has not yet been approved, partially because in Marrakesh at the meeting in March, the Government Advisory Committee, or the GAC, weighed in through their subsidiary, the Public Safety Working Group, weighed in and said there remain some significant concerns in the final recommendation about 3 issues: consumer protection, jurisdiction issues, and confidentiality. The GAC during this group, or during this meeting, called a session about the Privacy Proxy Services accreditation, which is a big issue, obviously, for all of us in the brand community, to discuss these issues and to determine whether or not they will be able to be addressed at some point, or if they should continue to hold up the final report. Their ultimate recommendation in the GAC communique from Helsinki was that the issues could be adequately addressed in implementation. And while they didn't go so far as to recommend that the board approve the final report, they made it clear that they weren't objecting to the board approving. And I think that the board will approve the final report of the Privacy Proxy Services Accreditation Group. And I will say there, in that report, which I was heavily involved in finalizing, there is some really good things for brand owners, including requiring relay of communication and some disclosure frameworks. And so the next step will be to enter into implementation stage to overcome some of these final hurdles and to actually have this become policy, which I think will be a huge thing for brand owners in order to address the issues that are presented by the use of privacy and proxy services, sometimes by somewhat nefarious individuals. So the next issue that was brought up regarding the Whois was the meeting of the Next Generation Registration Directory Services PDP Working Group. Right now, that group is doing a very deep document dive to make sure that any and all issues that might be related to any of the issues that the RDS group is working on are put into a sort of library of knowledge and summarized with certain aspects extracted and presented to the group for consideration. We are not yet actually fighting about what the issues are, including the purpose of Whois, privacy issues, access issues, accuracy, but we're getting our ducks in a row in order to enter into a fruitful and hopefully civil discussion about those issues. We're also identifying possible requirements of a new Whois or a new registration directory services, and as a group, ICANN and the leadership group of the RDS is performing community outreach. Here are the main issues that we're discussing in the RDS group: registration data elements, privacy, data accuracy, gated access, and then users and purposes. The purpose of this slide is to show that all of these are really interconnected and there's no way to really extract one from the other. For example, you can't really talk about privacy in a vacuum because privacy laws will often depend on the purpose or the user that's actually seeking the information. Like the level of privacy will depend on that. And it will also depend on which data elements we're talking about. Some data elements are going to be subject to stricter privacy requirements than others. So it's much, much more complicated than it might appear, and the group is doing a really good job of, I think, sorting through this and making sure that we approach these issues in an organized fashion. I think right now this group can be a little bit overwhelming for folks, but we're heavily involved in it, and we'll continue to give updates of the RDS group so that when there's opportunities for influence for brand owners, we can make sure that you are aware of when that's happening and how you might be able to best represent your interests in this group. Okay, so the next big issue, and this is probably the most controversial issue in Helsinki, there's always one. There's one controversy at every ICANN meeting, and this was it in Helsinki. Specification 11 is a provision in the registry agreement for new gTLD operators, and it relates to public interest commitments. So what happens at ICANN in this regard? So in Specification 11, the RA specifies that the registrar agreements, or the RAs, must include a provision requiring registrars to prohibit abusive behavior online, including trademark and copyright infringement, also malware, botnets, fraud, etc. So all of these this was a very heavily negotiated specification when it was amended to the RA several years ago. I remember when that happened. I think it was 2012 or 13. So it deals with the global public interest, which is a big issue, a very popular topic to talk about right now at ICANN. And ICANN has largely taken the position that, and this is especially a pet issue of the last CEO, Fadi Shahade, who is gone. The new CEO has started, but his legacy lives on with ICANN saying that they have nothing to do with protecting the global public interest and that their contracts have nothing to do with the global public interest. And there are several groups within ICANN, including the intellectual property constituency, that does not necessarily buy that from ICANN. So the IPC has asked ICANN to clarify what the PICs mean and who is responsible for enforcing what, because ICANN believes that as long as the provision is in the RRA, then their obligation to enforce Specification 11 ends there. But the content of Specification 11 has nothing to do with ICANN, and whether or not a registrar or a registry is falling down on their commitments to prohibit abusive behavior has nothing to do with ICANN or ICANN compliance. So without making a judgment one way or the other on that issue, I will just say that it is an issue. And then I would like to pass it back to Janelle, because the registrars are actually doing a number of things to address the concerns in the community, and I will applaud them for this as a group, to address some of the concerns regarding abuse mitigation. And I want to pass it back to Janelle to talk about that, since she is our primary representative to the registrar group, including the status update on the voluntary abuse mitigation practices document that they're working on. Janelle?
Thanks, Kiran. So as Kiran mentioned, the registrar group is working on drafting what we're calling voluntary practices for addressing abuse complaints. This is something that we've been working on as a group for well over 6 months, and the document is definitely a work in progress. But I do want to walk through kind of what the registrar perspectives are and what we're hoping to address in this document. We are in a unique, MarkMonitor is in a unique situation in this topic, and the fact that we have one side of our business that is enforcing on trademark and copyright infringement and other types of abuse, and then we also have the registrar side of our business that sometimes receives abuse complaints regarding domains under our management and how we mitigate those complaints. So from our perspective right now, I think the first thing that the Voluntary Abuse Mitigation Practices document is trying to clarify is when the registrar really is the appropriate point of contact for an abuse complaint. We see, as a corporate registrar, we see a lot of abuse complaints coming to us in regards to URLs. And as the registrar, we have no control over URLs. That information needs to go on to our clients. So as a registrar, if we do receive an abuse complaint, our three options as a registrar is to pass the information on to our client, suspend the domain name, or ignore the complaint. The last two options are not really options for us, so we're really just passing on information. And I think there is a really big opportunity for the registrars to do a lot of education within the entire community on what registrars really can do versus what a hosting company can do. Because a hosting company would have more control in responding to specific abuse complaints regarding URLs. But I think there's definitely a misunderstanding that a registrar has full control over the content of domains that they are managing. So we are definitely trying to flush out those details and create something that will be able to be used to educate everyone from law enforcement to public safety officials to people involved in the IPC community and anyone else that's involved with abuse complaints, and helping them understand when a registrar really is the point of contact and what they can do versus when the abuse complaint needs to go on to a registrant or a hosting company. We are hoping to have, we're continuing, like I said, to work on this draft. I don't think it's going to be ready for public consumption for at least a few months, but this is a topic that we'll be talking more about with our clients and others in the future. So next we will talk about the Inter-Registrar transfer policy. So this is another topic that I've been heavily involved in. So this is part of the 2013 RRA was a clause that registrars need to implement an Inter-Registrar transfer policy. This policy originally was meant to come in place in August of this year. However, ICANN has extended it to December 1st of 2016. So luckily, we will not see this happen next month, but before the end of the year, we will see this policy take effect. What this really means is anytime the registrant on a domain name is modified, both the current and the new registrant need to actually give approval for the change. And once the change has happened, they both need to be notified that the change has taken place. ICANN has said that registrars need to implement the approval method through a secure channel. However, they are not specifying what that secure channel is. So we will see registrars implement this process or this policy in very different ways, which may lead to some confusion within the industry, especially as this is a new policy and you have every registrar doing something slightly different. With the registrar transfer policy, it is optional for registrars to impose a 60-day transfer lock after a registrant change. That is optional, like I said, though, and we are looking to see if we can automatically opt out of that on behalf of our clients. That type of transfer lock makes more sense in a retail environment than a corporate environment. But what this could mean or can mean is when you transfer a domain name to a registrar, they can have a 60-day transfer lock, and then after that lock is expired and you update the registrant on a domain name, you'll have an additional 60-day lock. So they're really two separate locks, and they can go back to back. So this policy came to address two different problems. One is to prevent domain hijacking, so the practice of registrant details being updated without the current registrant's permission, and then the domain being transferred out of the registrar's hands, and the previous domain owner losing full control over the domain name, and the amount of time that it takes to resolve that type of situation. So that was the primary reason that this policy is being taken in effect. The other reason is something that we have seen with our corporate clients is the registrant details of a domain name being updated to our client without their knowledge. So they become the owner of a domain name, and they're unaware they are actually an owner of the domain name. So the goal, of this policy is to address those two facts. So next, we will pass it on to Kiran to talk about ICANN Accountability and Workstream 2.
So it wouldn't be an ICANN meeting unless we talked about ICANN Accountability, or at least that's been the state since about 2013. Despite the fact that in Marrakesh we did reach a milestone with ICANN Accountability where we got the IANA transition and ICANN Accountability proposal passed along to the U.S. government for approval, which they actually did accept shortly thereafter that meeting. There are still a number of pending issues that were put into a development process called Workstream 2. So that is those issues that were not necessary or possible to conclude before the IANA transition. To recap, the IANA transition was the transition of the assigned numbers authority contract from the U.S. government to a multi-stakeholder body of which ICANN is trying to shape themselves up. This is the accountability piece, to become that multi-stakeholder body that will accept responsibility for running the Internet essentially from a technical perspective, all of the things that are encompassed within the IANA contract. The issues for consideration in Workstream 2, which is currently out for volunteers, are listed here. So it's diversity, human rights, jurisdiction, so that deals with where is ICANN going to be located, will it continue to be a California nonprofit, what are the implications of that from a jurisdiction standpoint, what the Ombudsman role and function is. I will note that the current ICANN Ombudsman contract was not renewed, and so ICANN is actually currently without an Ombudsman, so it will be interesting to see how they develop that position from the ground up. Stakeholder organization and advisory committee, as well as staff accountability, will be an issue. Transparency is an issue. Something called the cooperative engagement process and independent review is something that's going to be addressed with Workstream 2 that sort of has to deal with community issues and complaints. And then, of course, the standards of board conduct will be part of that. So this should take a couple years. These are those issues that really couldn't be rushed into the timeline of the IANA transition, and so we'll be sort of addressing it. Itself. So, okay, so that's it. Next, we'll talk a little bit about how to get involved at ICANN, and of course, we sort of blew through a number of opportunities for involvement. In the slides, when we talked about the different policy groups, we're always here for questions. This was obviously recorded, and you'll be getting the slides after the presentation, so feel free to sort of leisurely flip through and see what you might be interested in and contact us with any questions. But here are some of the opportunities for active participation. The next meeting is in Hyderabad, India. ICANN 57, I will let Janelle tell you a little bit about that.
Yeah, so ICANN 57 is going to go to meeting format C, which is a 7-day meeting. So this is intended to cover kind of all ICANN topics. So it will go back to having an opening ceremony, a public forum, as well as your regular constituency days and additional topics. It is scheduled at an interesting time. So this meeting was originally intended to take place in Puerto Rico, but ICANN did move it. So this is, I believe it's a Wednesday through Thursday rather than your normal Monday through Friday meeting, which may make it, which makes the agenda a little unknown. So we're still unclear of what days exactly will be constituency days, as well as other topics. So more, I think, will be coming out in the next couple of weeks, or to outline what exactly the schedule will be for that meeting. But we definitely encourage our clients to get involved and attend these meetings when possible.
Yep, and each constituency and stakeholder group does have opportunities for travel support. So if you don't think that your company is going to plunk down for you to travel to Hyderabad, then you have an opportunity to get support through ICANN, through the fellowship program, et cetera, here are some of the constituencies that we're involved in that are particularly salient to our clients. The business constituency is my boss, Matt Serlin, is our primary representative to the business constituency. I am our primary representative in the intellectual property constituency. Janelle represents us on the registrar constituency. We don't have that listed here because it's not something that you can just sort of casually join. You do have to be an accredited registrar. We're an accredited corporate registrar in order to join. But if you're a .brand or you're interested in becoming a .brand, there's also a brand registry group, which you can get involved in. And then here's some more information. Again, these slides will be sent to you if you want to explore more about ICANN, or of course you can contact us directly. So in our last few minutes here, we do have some questions, and please feel free to type questions into the Q&A directly. So I'll just give you a couple of minutes to type in a question if you have some. We have some already, and I will be right back. Okay, so our first question from the group is, do we expect the RPM group to address premium pricing? I did mention that a little bit in the slide about the RPMs. We do expect the group to address premium pricing from the standpoint of the discussions about Sunrise, most likely. As I said, the ICANN did solicit input from the community about which issues were most near and dear to those of us that have been impacted by the new gTLD program, and premium pricing was definitely something that was brought up from a number of groups, including the IPC and I think the business constituency as well. So it will be addressed. We're not sure exactly when or where. If you're very interested in making sure that it gets addressed, the best thing that you can do is become a member of the group, or at least an observer of the group. And when we're talking about issues such as registry conduct and Sunrise and trademark issues and defensive registrations, speak out on issues like premium pricing, speak out on issues like reserved names, and Sunrise registration fees that are exorbitantly larger than general availability pricing, and represent the community on those issues. And we hope to see some significant changes to level the playing field for brand owners with regard to some of the registry business models. The next question is, why was the trademark post-delegation dispute resolution procedure, the PDDRP, underutilized? And is the RPM group discussing how to make it more useful? The second question, absolutely. That's exactly what the RPM group is doing with regard to the PDDRP right now. So a lot of people don't even really know what the PDDRP was. I was sort of guilty of that, although I knew of it only because I was involved in some of that policy development and implementation when I first became involved at ICANN in 2011. But the reason why it was underutilized is because it's a pretty complicated process, and I don't know definitively, but my opinion is that it was a sort of complicated procedure. It required a lot of expertise. It required a lot of understanding. It required lawyers, frankly, and it was expensive. And so those are all issues that the RPM group is going to be dealing with regard to the PDDRP, with regard to PIC DRPs might be something that we address, the URS, UDRPs, all of those issues, how complicated they are, what the cost is, whether it's worth it to recover the domain names that you're having issues with. All of that is going to be addressed in the RPM group in the coming months. So our final question is, on the enforcement side, was online sales of illegal products discussed, like pharmaceuticals, or just trademark and copyright infringement? Great question. So I think what you mean by on the enforcement side you're talking about our slide about the public interest commitments. And absolutely the online sales of illegal products like pharmaceuticals was discussed. Health and safety issues and fraud, things like malware, botnets, are always discussed when we're talking about abuse mitigation, public interest, registrars helping with that. And in fact, registrars are almost always more helpful when we're talking about things that relate to consumer protection, health and safety, and fraud issues than they are with any other issues. And so we do consider that a priority. Everyone that's working on it on all sides, including the registries and the registrars and ICANN, definitely consider the sale of illegal products, especially ones that harm a consumer. Anything that goes on your body or in your body is something that is a priority for all of us. And we fully expect that to be addressed even more robustly than trademark and copyright infringement will be. Although there is, of course, a very robust group of folks who are concerned about issues like anti-piracy, and I'm in no way saying that that is less important. I'm just saying that, generally speaking, in the discussion, things with about health and safety are taken more seriously.
Great. Well, thank you, Kiran. Thank you, Janelle. We appreciate you sharing that recap of ICANN. So I'd like to thank everybody for tuning in. As a reminder, we'll be sending out a follow-up email with a link to the webinar's presentation slides and a recording within the next couple of days. So be on the lookout for that email. That concludes our webinar for today. Thanks again for tuning in, and have a great day, everyone.